Welcome to Bishop Legal News, where we review appellate and Supreme Court decisions that may affect the outcome of your own case. In the September 2010 case of Curtis versus Lein, the Washington Supreme Court considered the application of the ancient doctrine of res ipsa loquitur to landowner liability. Res ipsa loquitur is Latin for, open quote, the thing speaks for itself, close quote. Res ipsa loquitur allows injured persons to prove negligence when they don't know the exact cause of their injury, if the injury would not ordinarily occur in the absence of the other party's negligence. Tambra Curtis was the girlfriend of Michael Stewart, the farm manager of Willow Creek Farm. They lived with their son at the farm in housing provided by Jack and Claire Lein. The farm property included a small pond with a dock. On April 25, 2004, Miss Curtis walked out onto the dock for the first time since she began living on the farm. A couple of steps onto the dock, the boards underneath her feet gave way, and her left leg plunged through the dock up to her hip. As a result of the fall, Miss Curtis suffered a fracture to her tibia. Miss Curtis brought a personal injury action against the Leins and Willow Creek Farms. The Leins removed for dismissal, which the trial court granted. The Court of Appeals upheld this dismissal, holding that res ipsa loquitur did not relieve Curtis of the burden of proving that the dock's defective condition was in fact discoverable. The Washington Supreme Court reversed. It held that when res ipsa loquitur applies, it provides proof of the defendant's breach of its duty of care. Therefore, Ms. Curtis made her case simply by showing, number one, that the accident would not ordinarily happen in the absence of negligence. Number two, that the dock was in the exclusive control of the Leins. And three, that she did not contribute to the accident. At that point, it was up to the Leins to rebut that proof with evidence that the defect was not discoverable or that there were other reasons for the accident besides the negligent maintenance of the dock. This case is important because many injuries occur on other people's property under circumstances in which all the information about the thing that caused the injury is in the possession and the control of the landowner. The Supreme Court has made it clear that under these circumstances, res ipsa loquitur can be used to carry the injured person's burden of proof. Legal news happens fast and can quickly affect the outcome of pending cases. Each case is unique, so this case does not necessarily indicate the outcome of your own case. Feel free to check back here for future editions of Legal News. I'm Raymond Bishop for Bishop Legal.